Hello and welcome to this alumni event which comes to you from the Lady Mitchell Hall on the Sidgwick site in Cambridge. My name's David Lloyd-Jones. A long time ago I was a student and later a teaching fellow in law at Downing College. In fact, the last time I was in this room was when I sat part 2 of the law tripos, which was a few years ago. I'm joined this evening by 2 leading experts in constitutional law from the Cambridge Law Faculty, Professor Mark Elliott and Professor Alison Young. Mark Elliott is Professor of Public Law at Cambridge. He's Chair of the Faculty of Law and he's a Fellow of St. Catherine's College. Mark's a former legal advisor to the House of Lords Constitution Committee, and he writes a blog, Public Law for Everyone, that aims to make public law accessible to non-specialists. Alison Young is the Sir David Williams Professor of Public Law at Cambridge. She is the director of the faculty's Centre for Public Law, and she's a fellow of Robinson College. Alison is a legal advisor to the House of Lords Constitution Committee, and she's also co-editor of the UK Constitutional Law Association Constitutional Law blog. Alison and Mark are the academic leads for the Faculty of Law's new project entitled Constitutional Law Matters, which is being launched in the Michaelmas term, which is about to start. This promises to be an exciting and a stimulating project, which will be hugely informative, but it will also encourage members of the public to think more deeply about current constitutional issues, which have an important bearing on life in this country. And the project has 2 principal objectives. The first will be to engage with and to attempt to answer the question whether the UK Constitution still works, whether it's still in good working order. And secondly, in considering that question, it will put public understanding of constitutional issues at the very forefront with a view to fostering well-informed public debate. There will be an opportunity to ask questions at the end of this session, and I'm told that the box at the bottom of your screens will enable you to do that. So please submit the questions during the course of the hour. Mark, Alison, welcome, and thank you both for joining us. I wonder if I could start by asking you to tell us a little more about the project and why it's thought appropriate to launch it at the present time.
Thank you, David. Well, I think that most people will recognise that over recent years, constitutional law, whether explicitly or otherwise, has very much been part of our lives, whether that's because of the Scottish independence referendum or Brexit, or more recently concerns about the way in which the pandemic has been dealt with in terms of legislation, advice, regulations, and where authority lies to make things of that nature. So I think as constitutional law academics, we're very conscious that it's part of a great deal of what goes on. But I think it's also apparent from some sort of sections of the media, politics, public discourse, that perhaps some of the issues and principles in play are not always as well understood as one might hope. And so, as you said in your introduction, a large part of the impetus for this project is really a desire to contribute to public debate, not just in terms of the substance, but also in terms of providing people with a way into issues which are often very complicated and can seem very sort of abstract, but actually are also really quite significant and have a really direct bearing on how we're governed and how the laws that we're all subject to are made and apply to us.
Well, Alison, let me come straight to the central point and ask you, why does constitutional law matter? Why should members of the public be interested in constitutional law?
I think it's so important because of building on what Mark was saying earlier, that so many aspects of what's going on at the moment link into aspects of constitutional law. So constitutional law is getting us to think about what the government is, how we construct a legislature, how we protect rights, how the judiciary works, and it's about understanding all the powers of those institutions in our constitution and how they relate to each other. And it might seem quite dry, but a lot of these issues become really important when we think about the laws that are made, how they're implemented, how they are interpreted, and all of these affect us on a day-to-day basis. So beginning to understand how the Constitution works, whether it's functioning properly, whether the laws that are made are justified and represent what the people want, is really important. So the more we can get people thinking about how these institutions work and what the principles are that should guide how they should work, the more we can get people engaged in thinking about all these issues that matter to them from a day-to-day basis, from things like what's going on in Parliament at the moment, how Parliament is structured, to things like why is it at the moment we can't get hold of petrol. All of those can link in to day-to-day issues that can tie back to how the government works on a day-to-day basis.
Now, it's often suggested that one of the great advantages of our Constitution is that because it's not codified, it's unwritten, it's more flexible, and therefore it's able to adapt more easily to changing situations, to changing conditions. Can I ask you both, do you detect any particular trends in our changing Constitution, and are these trends to be welcomed?
So I think one concern that I have, and one of the reasons I was keen that we should sort of take this project forward, is I think that there is quite an exceptionalist mindset in relation to, well, many things about the UK, including its constitution, and the idea that unlike almost every other country around the world, we can cope quite happily without a written constitution. That may be true, it may not be true, but I think that there's a degree of complacency that lies behind that assumption. And my feeling is that we've reached a point in our development as a country where it would at least be sensible to test that assumption. And I think there are a couple of things that really sort of crystallise that for me. One is that we famously manage in the UK with what we sometimes call a political constitution, which means a lot of the rules and expectations around how politicians behave and those in positions of authority behave are actually not governed by the law as such, but by tradition or constitutional convention, as we call it. And I do think it's possible to detect in recent years that system perhaps isn't functioning as well as we might hope, and that there's a greater willingness perhaps in certain quarters to test the limits of what the system will actually stand. And I think it's right to ask whether that system is still working. Alongside that, we have a system that is premised on parliamentary sovereignty, which means that politicians who sit in Parliament and make the law have enormous, legally unlimited power. And again, we look to politicians to exercise restraint in order to make that an acceptable feature of our constitution. And again, I think it's right that we pause and we ask whether or not that is working properly, and whether there are sufficient counterbalances in the system, political or otherwise, to make that an acceptable way of carrying on.
Alison, do you detect any particular trends in our changing Constitution? Welcome or unwelcome?
I do, and I think a lot of it is building on what Mark was suggesting about how we're used to seeing the UK Constitution as a political constitution, and we saw from sort of 1998 onwards a kind of move to put more principles on a legal basis. So we had things like the Human Rights Act, which incorporated the European Convention of Human Rights. We also had legislation regulating devolution and giving power to Scotland, Wales and Northern Ireland. And we saw more of a move to put things on a legal basis, but also more of an understanding of thinking about how we should limit powers in some way. I think what we're seeing now is almost a pushback against that, with some arguing that perhaps there was too much regulation and perhaps law was regulating too much. And so there's more of a question now and more of an argument in favour of thinking about, well, do we need a strong government? Do we need a government that is able to think about a particular public policy, to look at what would be in the public good, and to have the power to be able to enact that in Parliament without too many constraints? And so we can almost see a pushback in suggesting that perhaps there were too many legal constraints or too many political constraints on governmental power. And I think for me, that is to kind of in some way misunderstand how the Constitution works. I think it's important to recognise that we do need the government to be able to act in the public good, but there's also a need for political checks to make sure that it is in line with what the people want, because you have MPs representing the electorate in Parliament who are able to question government policies and see if they are moving in a direction that is enhancing the public good. But there also sometimes needs to be legal checks as well to make sure that government bodies are acting within the scope of their powers. So there's a kind of almost a balance of pushing towards either legal or political controls. And sometimes I think we need to take a step back and think about how to get a right balance between these two different types of controls.
And so you see it as a question of an adjustment of the balance between the different types of controls.
That's right.
Well, let's move on to look at some of the specific areas that are going to be considered in the project. And the first of those is Parliament itself, of course, arising out of what Alison has just been saying. And we start with Parliament and the sovereignty of Parliament. And we often hear that our system is unique because it's not codified and because it preserves parliamentary sovereignty. But what exactly do we mean by parliamentary sovereignty, and what are the implications of parliamentary sovereignty for the UK Constitution?
So as Mark was mentioning in his earlier answer, when we're thinking about parliamentary sovereignty, we're thinking about the idea that Parliament can make laws on any subject matter that it likes, and there are no legal limits to the laws that it can make. And so in particular, we're also thinking about, well, could there be limits from an earlier Parliament that said, well, for example, you can't breach human rights unless you use a special procedure or have a special majority. And that's what we often think about when we think about a codified constitution. There are some principles that are more important, that are harder to change, that are what we call entrenched, which makes them harder to modify. When you have a system of parliamentary sovereignty, then the argument is that you can't entrench in that way, because every parliament should be able to enact laws on any subject matter and shouldn't be restricted by earlier parliaments, even as to a special procedure, for example, to change human rights laws. And the reason this has consequences in the UK Constitution is because for us, there isn't this idea that there is a codified constitution that is over and above all laws. Legislation is the highest form of law in the land. And that means it can be easier for us to change the constitution more quickly. Sometimes changes can happen without necessarily people being aware of them, because they might not be aware of the legislation that is coming through in certain circumstances. And so I think that's one of the largest consequences of having parliamentary sovereignty in the UK system.
Lord Hailsham famously said, I think about 40 years ago, that our system is one of which results in an elective dictatorship. I mean, did you think he was right? And did you think that is a valid criticism today?
I think definitely at the time, I think there was very much evidence that that was the way in which Parliament was operating. And we can see that from the way in which our system works. So when we look at our electoral system, we have what we call first past the post. So whichever MP gets the most votes in their constituency gets the seat. Now, if there's only 2 people in that constituency, then that MP will have a majority. But if there's more than 2, they might not necessarily have a majority of votes cast. And so this system tends to produce a strong government. So you'll have a government that has a large majority of seats in Parliament, and so is able to pass legislation through, because all you need to pass legislation is enough votes in the House of Commons, and then in the House of Lords, and then the Royal Assent. So you can understand how the system can lead to that. And that gets coupled with some of the rules that work inside Parliament, what we call standing orders. And one of the most important is Standing Order number 14, which allows the government to effectively control time. So it decides what gets debated and for how long. And so that also means it can push legislation through quickly in certain circumstances. So there are definitely ways of developing a kind of seeing this as a system in a sense of an elective dictatorship. But a lot of it depends on the relative power of the government vis-a-vis backbench MPs, for example. So if the backbenchers aren't happy with the government and want to get modifications, they can get changes made to make sure the government has the votes in Parliament. And also it depends on how large a majority you actually have. So if you look at the events of 2019, we saw Parliament taking charge, because we had a minority government, and so it's easier for backbench MPs and opposition MPs to push measures through. So the system can definitely push towards an elective dictatorship, but whether we have one or not in practice very much depends on political power in Parliament at the time.
We've been promised constitutional change. The government, the Conservative Party, in its manifesto before the last election, promised constitutional change. What changes do you think we can expect to see?
Well, I think picking up on what Alison's been talking about, one of the changes that is now in the process of being made is the repeal of the Fixed Term Parliaments Act 2011 and the enactment of new legislation that will replace that act. And I think that, one way that we might understand this is in terms of the pendulum moving back a little bit more in favour of the executive. So the thinking behind the Fixed Term Parliaments Act, which of course was enacted in the context of the coalition government and the desire, I think, of the coalition partners that there was a degree of certainty and stability as to when the next election would be held and who could trigger that. But the key principle in the Fixed Term Parliament Act was that, generally speaking, Parliament should sit for 5 years. There should be a 5-year gap between general elections, and only in exceptional circumstances would it be possible to trigger an early general election. Now, actually, we've had a number of early general elections since that legislation was enacted, so it didn't necessarily do exactly what it was intended to do. It wasn't the absolute sort of restriction that perhaps was envisaged. But in bringing forward the new legislation to replace the Fixed Term Parliaments Act, I think the government is signalling its intent that it wants to realign how things work in this area, and it wants to reclaim the ability, in effect, to trigger an election at a time of its choosing. One of the criticisms of governments being allowed to do that prior to the Fixed Term Parliaments Act was that it effectively gave the sitting government a kind of inbuilt political advantage because it could decide when the political climate best suited an election from its point of view. So clearly, if this new legislation is enacted, which is very likely, then it will once again give the government that sort of advantage in terms of deciding when an election can be held. One of the other aspects of that legislation, which links through to an issue that we might come on to, is that there is provision in it which seeks to ensure that courts cannot become involved in reviewing decisions about these sorts of matters. And although the issues were slightly different, I think perhaps in putting that into the bill, the government has got in mind the second Miller case, which occurred in the context of proroguing Parliament, suspending Parliament for quite a long time in 2019 in the context of Brexit. And the reason that I mention that is that I think, building on what Alison was saying earlier, it goes back to this question about elective dictatorship and about where do the safeguards and the counterbalances come from. And if you were wanting to paint things in a cynical light, you might say that this new legislation about when elections can be held, in a sense, is evidence of the government attempting to shrug off control or restraint from both sides. In a sense, it's reclaiming the power from Parliament to decide when it can trigger an election, and at the same time it's trying to keep the courts out of, as it might be seen, interfering in decisions of that nature. So you might say, well, from the point of view of wanting to have a degree of balance and a degree of sort of control, that this legislation could be presented as an example of the government moving away from that and trying to re-establish the sort of strong government model that Alison was talking about earlier on.
In the context of dissolution, there were, as I recall, a number of conventions attached to the exercise of the power to dissolve Parliament. Will these conventions be revived in the legislation as a result of the bill?
I think that's an open question. I mean, I think that the legislation in itself can't achieve that. I think that my hope would be that those conventions would revive because, as I was saying earlier, we do look to the political constitution to provide a degree of regulation where there aren't sort of hard legal restrictions on what the government can do. I think the concern would be that if we reinstate the government's unilateral legal authority to decide on these matters, and the political or conventional sort of factors that sort of limit that authority don't also revive, then once again we're into this sort of picture of the reassertion of strong government, but also, doubts about the sort of adequacy of the controls which exist around that.
Yeah, the government did, when they published a draft bill to replace the fixed-term parliament, they also produced a document called Dissolution Principles, which set out the principles of when they thought the parliament could be dissolved. So the power belongs to the monarch, and the Prime Minister can request the monarch to dissolve Parliament, and these dissolution principles will set out when the monarch could be able to refuse. But these dissolution principles are very different from a set of principles called the Lascelles principles that were established, I think, way back in the 1950s, I believe. So there's some discussion as to how far the dissolution principles replace the early Lascelles principles or a reworking of them. So I think a lot of that will come out in political discussion as the bill progresses through Parliament.
Thank you. Well, let's move on. Let's move on from the legislature to the judiciary. There's nothing new, I suppose, in the existence of tensions between the executive and the judiciary. But we do seem to hear a great deal of criticism at the moment about judges overreaching themselves, and criticisms of judicial activism. Judges just go too far in seeking to change the law.
So I think that's become an increasingly sort of frequent refrain in recent years. As you say, it's nothing new. I mean, one can go back to the early days of, for example, the Blair government, and there were similar tensions. So it certainly isn't something which is unique or, I think, confined to one political party or one kind of government. But certainly, I think, in the last 3 or 4 years, the tension has been very notable. I think that the Brexit litigation perhaps has been something of a lightning rod in relation to the original Miller case, which ruled on Article 50 and said that the government couldn't unilaterally trigger that. It had to go to Parliament and get sort of permission. And the other Miller case that I mentioned earlier about prorogation. And I think that in some quarters they were seen as quite interventionist judgments, and they have been seen by some commentators and politicians as examples of judicial overreach. And I think that's what has built into, or it seems implicit that that's what's built into some of the thinking coming out of the government in the last year or two, with the review of judicial review, and the review of the Human Rights Act, one of which is sort of still ongoing, the Human Rights Review, and the judicial review work is now sort of reaching fruition in terms of legislation.
So what does the report of the review on administrative law have to say about judges overstepping the mark?
Yeah. Well, what's interesting, I think, about the review of administrative law is that if we take the review itself in terms of the report that the expert group produced, it's actually very measured and very balanced. I think it acknowledges that there are some tensions. It acknowledges that there are certain cases that might be seen as going further than we might have expected. But on the whole, it takes a very measured approach. What's interesting is when we sort of look at what came before and after, because the terms of reference that the government drafted for the review seem to open up the possibility of very far-reaching changes to the law of judicial review, which, if they'd been taken forward, could have resulted in some really quite dramatic reductions in the court's powers. But the review itself didn't really bite when it was given that sort of opportunity. Interestingly, when the government responded to the review, one sensed that there was almost a degree of disappointment that the report hadn't gone further than it did. And so the government's response appeared to contemplate perhaps taking more radical action than the review itself had suggested. In the event, The Judicial Review and Courts Bill, which is currently going through Parliament, is very modest in nature. It imposes some limits on certain kinds of judicial review arising from judgments of the upper tribunal about permission to appeal, which is a fairly self-contained and in some senses quite technical matter, although it could have broader implications. And it gives the courts a discretion to limit the effect of the remedies that they issue in judicial review cases. But of course that goes nowhere near as far as some of the ideas that were suggested by the government, which might have actually required remedies to be limited in certain circumstances. So in the end, quite little has come of this, but I think that we shouldn't lose sight of the fact that in the background there has been this quite significant discontent in government about the perception of judicial overreach.
Alison, I don't know if you wanted to add anything on that.
No, I think that's right, and I think so in particular there were some suggestions in the report not just about limiting remedies but also imposing more vulnerability for Parliament to enact what we call ouster clauses. So these are clauses that stop judicial review in a certain area, and that was something that was not picked up on. So I think there is this element of perhaps a backtrack in some sense, so a very different element of what the report said, how the government responded, and then the bill we've ended up with, which is making quite minimal changes.
So far as remedies is concerned, the bill seems to focus almost exclusively on giving suspensory effect to a quashing order.
That's right. So it will give a power to the court to say, well, we are going to quash a particular decision, but rather than taking place immediately, it could take place in the future. So, for example, there was one famous case where quashing a decision meant that the UK would be in breach of international obligations. So to have the power to say, well, we will quash, but we'll give you a chance to do something else to bring yourself in line with international obligations might be a good power to give to the court in those circumstances.
Yes. We must move on. The next topic on the list is devolution. I suppose that one of the consequences of the COVID pandemic has been that it's brought home to many people who were previously unaware of it, the significance of devolution within the United Kingdom. The differences between the regulatory regimes which were in force in different parts of the United Kingdom have been starkly apparent. And it may be that when the history of devolution comes to be written, it may be that this will be seen as quite an important milestone in the development of devolution. Alison, could I ask you what you see as the key constitutional challenges, the key issues in relation to devolution?
Of course, thank you. I think at the moment a lot of the key issues have stemmed from Brexit. So, for example, we used to have a single European market when we were members of the European Union. And then, of course, that means we have to think about, well, if we have a system where there can be these divergent rules, as we saw with COVID, how do we ensure that there's still a kind of single market that allows goods to move across different countries? Also, with regard to Brexit, there are issues in particular with regard to Northern Ireland. So we have a very complex protocol, the Northern Ireland Protocol, which deals with issues that arise because Northern Ireland has a land border with Ireland. So we need to think about how we were allowing goods to still move across between Northern Ireland and Ireland, and also to make sure we could still have goods moving between the other aspects of the United Kingdom and Northern Ireland. So I think that has created quite a few tensions, and so we need to think about that going forward. And also, as we've mentioned, aspects of Scottish independence as well. So I think there's lots of things coming out of Brexit. And also, I think COVID has really drawn our attention to the fact that there can be issues like health that are devolved, where there's a need to think carefully about how do we have a unified solution, but also how do we make sure there's sufficient local divergence when that is needed to respond to a particular health issue in a particular part of the United Kingdom. So I think it's particularly COVID and Brexit are really posing challenges for devolution going forward.
Could you tell us a little more about the Internal Markets Act? As I understand it, when we were in the EU rules on the single market ensured that there was a single market within the United Kingdom. We had to comply with EU rules. Now that that's gone, that has to be replaced by a new system. But what impact does that system have on the balance of powers between the devolved legislatures and executives on the one hand and the centre on the other?
I'd say it's a very difficult question to answer, so I'll try my best. So some of the difficulties that have arisen is precisely because we're trying to make sure we can have a single market. So you might imagine, for example, let's say Scotland decided that all pens had to be recyclable because it felt this was a good way of recycling products and protecting the environment. So in that scenario, Scotland would say, well, we'd like to enact this law, and they'd have the power to do so if it was in their devolved powers. But the Internal Market Act says, well, if you can sell a good lawfully in England, Wales, Northern Ireland or Scotland, then it must be able to be sold lawfully elsewhere as well. So Scotland could enact its law, and then England could say, well, we don't want this. We are going to allow you to have pens that don't have to be recyclable. And because that single-use pen could be sold in England legally, then the Internal Market Act says, well, it has to also be sold legally in Scotland as well. Now, there are some circumstances in which you can justify divergence, but one of the situations you used to be able to justify divergence in the EU was on environmental grounds, but that's not in the Internal Market Act. And so because of these differences, the devolved powers see this, in a sense, as changing the balance of power between Scotland, Wales, Northern Ireland and the United Kingdom. And so this has created tensions. And these tensions, they're not just in the legal regulation, but there was also a development of common market frameworks that was happening between the different governments to come up with rules which would be the same or where you'd allow divergence. But there's also tension between how we regulate the common market frameworks and how we regulate the law that allows the goods to be sold. So you can understand that although it doesn't say you can't enact this law, it can make it very difficult for the devolved bodies to perhaps enact laws in certain areas, and that's why they're getting concerned about the balance of power. Whereas Westminster would say, but it's important to have that internal market, and so we need to be able to have these provisions to make sure we don't undermine the economy.
Thank you. Mark, I know you've got a particular interest in another aspect of devolution. I don't know how it's pronounced, Evil?
I think so.
Evil. English votes for English laws. I mean, this is a product, I think, of the asymmetrical system of devolution that we have in this country at the moment. But as I understand it, Evil has been abolished, almost unobserved, and uncommented upon.
Yes, so English votes for English laws, as it's called, was introduced in the wake of the Scottish independence referendum. In fact, I think David Cameron essentially sort of suggested the idea the morning after when he said this, Scotland has now voted and now England must be heard. And I'm not quite sure what the logic of that was, but anyway, that was the genesis of it. And the idea was to try to answer what's referred to as the West Lothian question, named after the former MP for West Lothian, who I think first posed it or put it onto the public agenda. And the question essentially is that now that we have devolution in Scotland and Northern Ireland and Wales, which means that there are certain matters that, let's say, MSPs in the Scottish Parliament can make law about for Scotland. And of course, on those matters, English MPs wouldn't be involved because it would be a matter purely for the Scottish Parliament. The question is, well, if that's the case, why should, say, Scottish members of the Westminster Parliament be involved in passing laws that only affect England? So it's a question that arises in the first place because of this sort of asymmetrical structure that we've adopted, where we have legislatures and executives in some parts of the country, but not in England. There are no England-only institutions. And the answer that English votes for English laws provided was that when laws that were only affecting England were being passed by the Westminster Parliament, there would effectively be a double procedure whereby there'd need to be a majority of English MPs in support of the provision, and then, as usual, a majority of all MPs. And this was a very sort of pragmatic way of trying to resolve a problem that arose because we don't tend in this country to sit down with a blank sheet of paper and think, how should we design things? We kind of muddle along, and when a problem arises, we then think, oh, perhaps we ought to try and solve this. But it's very, striking, as you say, this pretty quietly, this was all dropped in the summer. And one thing that really, I think, brings home to me is, this much vaunted flexibility of the UK constitution, that actually a very significant constitutional change in some senses could be done away with in this under-the-radar kind of way, which would be very unlikely in a system that had a written constitution and special procedures for changing the constitution and so on. And it occurs to me that that may be an illustration of flexibility perhaps not being a good thing, because it means that these quite significant changes can be made with very little debate and very little scrutiny.
Thank you, thank you. Now, Alison, one aspect of devolution has been the role of the civil servants. And I think quite an important role is played, a very important role is played by civil servants behind the scenes, probably receives very little attention, but they are, as I understand it, responsible for resolving tensions between different parts of the United Kingdom, for example, by the operation of memoranda of understanding, trying to reach agreement on disputed points, which can then be presented to ministers for approval. So to what extent does devolution depend on the work of the civil service as the oil in the machinery, and how do these interactions work in practice?
I think that's exactly how it works. They are the oil in the machinery in a sense, because there are lots of areas where you do need the devolved governments and the Westminster government to be able to come together, to be able to find solutions that will work for the UK, while also recognising local divergence. So in the common market frameworks, for example, to try and find these kinds of areas. And it's civil servants sort of interacting with each other that tend to be the first line of trying to reach these compromises and agreements. And if they can't reach an agreement, obviously they'll be instructed by their ministers, but they want to try and then present something to the ministers that would be an agreement that would work. Because if you can't resolve it at that level, there are very few mechanisms that you could use to resolve it without it becoming a dispute between the ministers, which can then become very difficult in terms of turning into a political power struggle. So a lot of trying to reach compromise is going on sort of in the background, in a sense, to try and reach that. And there are some discussions at the moment to try and change intergovernmental mechanisms so that there might be the possibility of having a third party to resolve these tensions, but we're not there yet. And so it's almost like if you can resolve the tensions between the civil servants and come up with something that works, it's much more effective than if you're then having to rely on just a sort of political disagreement that it might be very difficult to resolve.
And Mark, I think this leads to the wider question, doesn't it, about the role of the civil service generally. What should be the role of civil servants? How should they perform their tasks of the administration of government without undermining the accountability of government for governmental decisions?
Yeah, I think that's been a very long-running question, that what is the proper relationship between civil servants and ministers? And then how does that intersect with the proper relationship between government and Parliament? And I think that's another sort of site, I think, of this struggle that we've been sort of touching on at different points during our conversation today, about to what extent is there a meaningful degree of oversight and control, and to what extent is it possible for the government to free itself from that and not to really be subject to it in such a meaningful way. So it's not at all uncommon, I think, for ministers to hide behind distinctions between policy judgments that they're responsible for, and then operational and implementational matters that civil servants are responsible for. And I think, the theory teaches that ministers are responsible for what their civil servants do. and that in that sense there is this joined-up system of accountability that culminates in Parliament overseeing the work of the executive. But I think most people would agree that actually in reality there are quite a lot of disjointed parts of that system, and that is one of the factors, I think, that makes us wonder whether or not we've got it right in terms of the degree of scrutiny and the mechanisms of scrutiny that we apply at present.
Thank you. Well, we've covered a lot of ground, and while we've been speaking, a large number of questions have been flooding in. The only question is whether I'm going to be able to master this sufficiently to be able to address the questions to you. An anonymous attendee asks, do you think that the procedural rules of Parliament carry an inappropriate weight in our Constitution?
It's not necessarily that it's inappropriate. I mean, you do need procedural rules to be able to work out how Parliament is going to operate in certain circumstances. And I think most of the time we don't necessarily see them in operation. I think they really became something that the public was thinking about in 2019 when we saw different arguments about whether you could enact a private member's bill in certain circumstances and what time you would have. So I think there needs to be rules there to make sure debate operates properly. I think perhaps if there's a problem, it's that these are created inside Parliament and it's up to the Speaker to decide how to interpret them. And maybe if there is an issue, there's more of an issue of making sure there's sufficient public understanding of what they are, how they operate, and what the consequences are. And perhaps maybe more democratic deliberation as to what those rules that regulate Parliament should be.
Mark?
Well, I think all I would add is that I think maybe a fundamental problem, but I don't have a solution to it, is that I think it's never really in the interests of those who have their hands on the levers of power in Parliament to make Parliament more effective at doing its job, which in some senses should be making the government's life more difficult and giving the government a harder time in terms of scrutiny. And so the paradox, I think, is that while we can all see ways in which Parliament could improve, the progress towards that is quite glacial. I mean, there have been improvements in the last 10, 15 years, but progress is quite glacial, and it's often taken pretty spectacular events such as the MP's expenses scandal to actually force the pace of change. And I think that underlying problem that those who are sort of in control of the system have little incentive to improve the system, I think that's almost irresolvable difficulty, actually.
There's a question here from Sebastian Wormel. Two questions, in fact. Is government good at drafting legislation? And is Parliament good at scrutinising it?
So we could be here all night answering that one. In terms of drafting legislation, I think it's important to recognise that it's not just the government that drafts legislation. So there is a special department within government whose job, Parliamentary Council, whose job it is to go away and draft legislation. So the government is there to decide the policy. Then the Parliamentary Council Office will draft the legislation and the provisions using their special sort of legal skills to draft it. So I guess the question you're really asking is Parliament good at choosing the right policies, or is the government good at choosing the right policies? And that's really a question of how far we think any particular government is paying attention to the wishes of the people and being able to enact those wishes in legislation. In terms of how good is Parliament at scrutinising legislation, this is when it becomes more difficult because, again, we're looking at issues of how well you can get parliamentary debates and discussion. And some of the difficulties we find in the Westminster Parliament is because it's more adversarial, it isn't necessarily always the case that questions and scrutiny are about scrutinising. They could be more about, but I would be a better government if I was to do something else, rather than necessarily focusing on a piece of legislation. And because of the standing order rules, you can restrict the amount of time you spend debating and scrutinising. So I think if you look at comparative research, so I used to teach European Union law as well as UK law, And if you looked at the research, it was easier for a member of the European Parliament to successfully get an amendment to legislation than it was from a member of the UK Parliament to do so. So I think we have to ask ourselves, is this really effective scrutiny in those circumstances?
Martin Genke asks whether there's a problem with the executive being so enmeshed in the legislature.
Whether it's a problem, I think, is a matter of opinion, but it's certainly a very significant feature of how our system works. So without fundamental change to the system, that is simply a fact of life. I think that the way that I would come at the question is to say, well, in realistic terms, that isn't going to change. But do we have the structures and processes in place that we need in order to take into account that fact of life and to make sure, for example, that the inevitable influence that it gives the government over Parliament is properly counterbalanced, both through the way that Parliament actually works and organises itself, and that raises questions like how time is allocated, and the opportunities that opposition parties and backbench MPs have to challenge the government. And it also brings into play questions about what is there beyond Parliament to exert meaningful control and oversight over government, whether that's in terms of judicial review or other features of the Constitution. So is it a problem? Well, it certainly can be. I think the question is, do we have adequate steps in place to acknowledge this and then to take corrective action?
Susan Murray asks whether our voting system is fit for purpose in enabling a wide range of views in the country to be represented.
I think that is a very important question that we need to ask, because we have first past the post, and as well as producing strong governments, that also can make it very difficult for smaller minority parties to find any form of representation in Parliament. And it also means individuals might think, well, there's no point in voting for this party because they're not going to win a seat. So what's the point of voting for them? I might as well vote tactically and vote for somebody else. So the voting system can make it harder for smaller minority parties to get representation of views and to find seats in Parliament. But again, it comes back to this is the whole problem of thinking about these deep constitutional issues. Those who prefer a strong government would say, but if we had too many political parties and a coalition government, we'd never get anything done because we'd be too busy arguing about things. Whereas those who think, well, this isn't sufficiently representative, would want more representation. And this is why we have, so if you look at the devolves, for example, they have the additional member system. So you have a kind of combination of first past the post and then aspects of proportional representation for additional members. So maybe it's time to think about whether those kinds of systems would work well in Westminster as well.
There's a question here from Garth. He asks, how much of a hindrance is the lack of a UK written constitution? I know that in New Zealand, for example, there's a move to adopt a written constitution. Should we be doing the same thing?
I guess it depends what we want to try to achieve and what the absence might be hindering and in turn what the presence might achieve. It would certainly, I think, change things radically. It would affect most of the things that we've talked about, I think, this evening in terms of the balance of powers, the extent to which we rely on the law and the courts as opposed to political tradition and convention. So depending, of course, on the content of a written constitution, it would change things radically, potentially. But some people would say, well, actually, that would be a bad thing because it would bring the courts into more matters. It would change the way that things work in deleterious ways as well as positive ways. So I think, like with the question about the voting system, it's a question of what it is that we're trying to achieve. And we have to get that question sorted out and answered before we can then decide what do we want to do to actually get to that destination, whether that's in terms of how we vote or in terms of a written constitution.
There we are. Well, we're rapidly coming to the end of this session, but can I offer you an opportunity, very briefly, each of you, to make some closing remarks?
I think all I would add is that I think these are the sorts of questions that we very much want to explore as part of this this project, and I think that starting a conversation about these issues, not just amongst lawyers but actually amongst a broader group of people, can only be helpful. But I think some of the questions have highlighted that until we are clear about these fundamentals, it's very difficult to know what structures and arrangements we should put in place to actually achieve them.
And I think it's important for the public to understand these issues. So when we think about should we have a written constitution, we also need to think about, well, who should be making that, and how far should we be involving the public in developing these constitutional principles as we go forward.
Well, thank you both very much on behalf of everyone in the audience. And although we're in an empty Lady Mitchell Hall, almost empty, there are a large number of people out there. I can tell you the questions have been flooding in. And I'm only sorry that we've not got more time to address many more of the questions. We'll be here all night, I can promise you. But thank you for your illuminating contributions on these complex and fascinating issues. It seems to me that you've been very effective this evening in showing why constitutional law matters. And you've whetted our appetites for the further events in the series, all of which, as I understand, are going to be available online. We're very grateful to you, and my thanks also to the audience for the questions that you've submitted. And finally, just a word about the future events in the project. The next event in the project will take place on the 20th of October. The speakers will be looking at the functioning of Parliament and focusing on whether this places the balance of power in the hands of the government or in the hands of the legislature, and what that tells us about the nature of our constitution. There'll then be 3 further events looking at the role of the judiciary, at devolution, and the civil service. And details of all of these future events are available on the website, and the address is www.constitutionallawmatters.org, and we hope that you'll all be able to join us for these future events. For now, goodbye from our speakers. Thank you very much to them, and goodbye from me. Goodbye.